And we're going to get started. I'm assuming everybody can hear all right. Good morning. My name is Jeff Kushner. I'm the statewide drug court coordinator for Montana. We got about 50 people on the line at this point, and there are several judges, and we're happy about that. I just want to mention that these 3 days from 8 in the morning until 10 in the morning or so, Wednesday, Thursday, Friday of this week, are taking the place of our statewide conference, which we have moved to September 21 through 23 of next year because of the pandemic. Please mute your connection because we're getting some feedback. I want to take this opportunity to really thank NADCP, Carolyn Harden in particular, for helping us with these 3 days and the presentations. She is a delight to work with, as always, and I very much appreciate her help.
And it appears that we lost Jeff for a moment, so hopefully he will be logging us back in. So as he is coming back into the office, I am Shane Wolf. I'm the Director of E-Learning with NADCP. And one thing just to let you guys know, when we go through the training or the sessions today, if you do have any questions whatsoever, please write them in chat. I will be gathering all the questions in chat.
Judge is dropping off.
And I will place them so that we have an opportunity for Doug or Terrence to answer them at the end. And if not, I'll be sending those questions to them to answer, and then Jeff will be able to distribute. It appears that Jeff is back, so I'll hand it back to him.
Yeah. So let me introduce Shane. Shane is the Director of Electronic Learning for NADCP. He joined NADCP in 2016 and has a strong passion for treatment courts and 15 years experience in treatment, juvenile, and adult supervision. Served as the court coordinator in Clark County, Washington, where he managed the DWI hybrid court, the Veterans Court, and the mental health court. He is accustomed to wearing many different hats, from implementing new programs for the first time for juvenile offenders and detention alternatives to seeking for a change and aggression replacement therapy. He pursued his master's degree to evaluate programs and integrate technology into the curriculum. He's worked as an adult probation officer and a juvenile probation officer, guardian ad litem in Washington. He's got a master's degree in instructional design from Quinnipiac University and a BA in psychology from Eastern Washington University. Shane has done work in Montana before. We've appreciated all of his help historically, and we appreciate his help today. So Shane, will you introduce our speaker for the morning, or the first speaker?
Yes, thank you so much, Jeff. So we are all excited for our speakers today. Our first speaker this morning doesn't really need much of an introduction, but I'll do my best to introduce Doug Marlowe. He's the Senior Scientific Consultant for NADCP, and he's also the Senior Science and Policy Advisor for Alcohol Monitoring Systems and the CE Training Consultant for Global Institute of Forensic Research. He's a double threat as a lawyer and a clinical psychologist, and he has done much research in the study of the coercion of substance use disorder treatment, the effects of drug courts and other diversion programs, and involved with the criminal justice involved in behavioral treatment programs. So we are very excited to have Doug here today, and I will hand it over to Doug, who will lead us off in this morning's session.
Thank you, Shane. Thank you, Jeff. Welcome, everybody. Thank you for inviting me to speak with you today. I've been asked to deliver probably one of my more controversial or provocative presentations on signs that you might not be a drug court. And I do hope you understand that the purpose of this is not to offend anybody. It's not to exclude anybody. It's not to hurt anybody. The purpose of this provocative title is to remind us what it means to be a drug court. I think that as drug courts have proliferated around the country, more and more people have joined the field. Sometimes the basic elements of the model, the basic philosophy, what we are, who we are, why we are here, have been forgotten, or some people have not been taught those lessons appropriately to begin with. And there are many drug courts out there functioning under the title of a drug court that really do not follow the core defining elements of the model, which raises questions about model creep and whether we are in fact maintaining our integrity as a profession. So that's the purpose of this talk. It's to get us back to our roots, not to exclude anybody. Before I get started, I should say that this talk is supported by Bureau of Justice Assistance, but the things that I say, my opinions, are not those of BJA or any of the other DOJ departments, not necessarily the positions of any DCP or the Montana Drug Court Association. These are my individual views. So we have two defining documents in the drug court field. We have the 10 key components, which came out in the late 1990s. The 10 key components define what a drug court is. They came out and told the world, we have this new program thing. It's somebody needs to, please, I'm getting a lot of noise. So if somebody, whoever's not muted, please mute. The 10 key components are a statement of what it means to be a drug court. The word key means they have to be there. And if you're not following these, then you are in fact not a drug court. They are not necessarily rooted in evidence. At the time, we didn't have research really yet. We had some research, but not much on whether drug courts worked, how they worked, who they worked for. We believed in a model, and we certainly had research out there that many of the things we were endorsing were shown to be effective in other contexts. But we were really saying, this is our philosophy, this is our model. We're not saying it's the only model, but we are saying it's our model. If you are not following the 10 key components, then by definition, you're not a drug court. If these are key components, they must be present to be a drug court. Then if you are not following these things, you are essentially not following the model. The adult best practice standards, adult drug court best practice standards, do not replace the 10 key components in any way. They assume that a program is a drug court. They assume that a program is in fact incorporating the basic elements of the model, and they're trying to define what an excellent drug court is, what separates the more effective from the least effective drug courts. So if the 10 key components define the floor, the base, the lowest level at which you can be defined as a drug court, then the best practice standards define the ceiling, what it takes to be the best drug court. They are, in fact, rooted in evidence of effectiveness. Nothing gets into the best practice standards unless they have been proven empirically to improve outcomes. If you are out of compliance, then you need training and technical assistance. So if you're not following the key components, you're not following the drug court model. If you're not following best practice standards, then you need more training in order to apply the model better. And this is the fundamental distinction here. We have spent a lot of time talking about the best practice standards, and I think we've lost attention to the 10 key components. So I'm going to talk about some general categories of issues where drug courts have deviated from the model, arguably to the point that they're not really functioning as drug courts. The first is that drug court is a different jurisprudential philosophy. It's a different jurisprudential animal. It is not a diversion program. The criminal justice system has diverted people out of the criminal justice system into treatment system for decades. Drug courts are not a deflection program, which prevents people from coming into the system in the first place, deflecting them pre-contact. It is not a decriminalization measure. It is not a medicalization measure. It is not a deinstitutionalization measure, which means it doesn't believe in reducing the authority, resources, and input of the criminal justice system. It is the criminal justice system. And it recognizes the importance of the criminal justice system being involved in the management of these cases, but that it must do its job right. Although it includes restorative justice components like community service, fines and fees, victim impact, that is not considered to be the core or certainly the only part of the intervention. Drug courts are, when all said and done, a negotiated sentence or disposition. They are a disposition in the criminal justice system. As such, the public is a party to the action, just as the participant is a party to the action. Drug courts do not follow all or nothing principles in pretty much any area, with very few exceptions. We do not say that this is either a personal issue that requires exclusive privacy and confidentiality, nor is it something in which we focus all of our efforts on the public good. We do both. It is a public forum and a public record. Now, part of this is not just that's what it is, that's what we believe it ought to be when serving high-risk, high-needs people. Part of this issue is the notion of courtroom as theater. Drug courts adopted that term right from the beginning. We behavioral scientists refer to that as vicarious learning. The idea is that if I reward you for doing well, if I encourage you for doing well, if I give you treatment for doing well, then I will improve your behavior over time. But if in addition, you watch me doing the same thing for other people, and if when you receive sanctions, when you do things you're not supposed to do, but you also witness that happening to other people, you learn faster. And so the idea of courtroom as a place where we are enacting basically a script and people are observing interactions, not just with themselves, but others. In other words, the drug court model doesn't follow the model in which everything happens in the privacy of a one-on-one interaction between the participant and their counselor and all else is confidential. That's not the model. We certainly understand that there are many things that should be confidential, should be discussed in treatment alone and not in a public forum. But the broad aspects of the case are handled in a public forum. Of all the key components, the one in which the key components say ongoing judicial contact is essential. You would assume if the word key is in the document, we don't have to say that inside the document. But here, the theory is that court contact, judicial contact, is the defining, among the most powerful, among the most unique components of a drug court. You may agree with that or not, but that was the theory. And there were a number of reasons for that. One is the symbolic value of the black robe. And many participants will say the idea that a judge, somebody with the power, the authority, the charisma of a judge wearing the black robe, sitting up there on the bench, having the flags and the seal of the state behind them, that person taking an interest in me is very impactful. And in fact, participants say that, and we believe that that was critically important. The notion of due process. Research was already beginning to uncover in the 80s that whether or not somebody won an argument, whether or not they won a legal case, whether or not they won a debate, was not the biggest predictor of how satisfied they were with the outcome. The biggest predictor was how fairly they were treated in the context of that decision, whether they received due process, whether people gave them a reason for the decision, whether people listened to both sides of the debate. We were already beginning to understand this. And there's one place where due process is virtually non-existent, and that is pretty much in the substance use and mental health, in many respects, treatment systems, where if you don't like what your counselor's dishing out, if you don't like the kind of treatment you're receiving, you can leave. And many participants do by voting with their feet. But they don't get to go to their counselor's supervisor and say, I don't agree with my counselor, I want something different. There's no ability to challenge decisions. As a practical matter, on probation and parole, and certainly in jails and prisons, participants don't get to challenge a decision. They don't get to have it reviewed. They have no right of appeal because basically this is all for their good. Drug courts were meant to follow due process, that there was procedural fairness. All the accoutrements of a courtroom were believed to be therapeutic, and there was research suggesting that. They have a right to appeal. It is not true to tell somebody that if you try to appeal what we said here in drug court, that's proof that you're not ready to get better, which a lot of drug courts unfortunately do. They have a right of appeal, and that was meant to be part of the process. And as I said earlier, they had a right to be treated in a procedurally just and procedurally fair manner. Drug courts do not accept the argument that the substance use, that addiction, that drug dependence is either a public health or a public safety issue. We don't accept the argument that it's either a treatment issue or a criminal justice issue. It is both to varying degrees, depending on the risk and need level of the individual, and only using the power, the authority, the fairness, the procedures of the court can be effective for high risk, high needs individuals. That's the model. You don't have to agree, but that's the model. Now, I shouldn't have to say this, but it was always understood that the Constitution applies. And unfortunately, this is something we have to continuously remind ourselves. It is true that procedural due process is relaxed in drug courts, but it is not abrogated. Participants have a right to a fair hearing commensurate with their imperiled interests. What does that mean? It means that in a drug court, there are certain rights criminal defendants have that if we give them those rights in the context of a drug court, the drug court can't do its job. So of course we have to give them the right, we have to have them waive the right to a jury trial because we're not going to be having a jury trial in a drug court. Give them the right to be free from self-incrimination to a certain degree. Otherwise, we wouldn't be able to force them to take a drug test or to ask or to answer our questions when we ask them about their drug use. We ask them to waive speedy trial rights because drug courts take a while to achieve people's treatment needs. If a right does not need to be waived in order for the drug court to do its job, then it is not intended to be abrogated. And the big one here is the right of defense counsel. There is no reason to think that participants should be waiving defense counsel rights in drug court. In fact, research suggests that participants do better with defense counsel representation in drug court. So required waivers of defense counsel representation are probably and have often been found to be unconstitutional unless irrevocable at will, and in fact, inconsistent with the drug court model. So we have gone too far. We've had participants waive due process hearings. If you're going to get a jail sanction, the fact that you can test it proves that you're in denial. That is itself a constitutional violation. It is an unnecessary waiver of due process in a drug court. Substantive due process was never intended to be waived. For the non-lawyers in the group, procedural due process are the rights you have in terms of the procedures to be followed. I have a right to counsel. I have a right to notice. I have a right to an opportunity to be heard and to explain my side of the story. Those are your procedural rights. Your substantive rights are the rights not to be treated in an arbitrary, capricious, because I said so manner. Therefore, judges in drug courts have discretion, but it is not unbridled. It must be rational. What does that mean? It means no condition in drug court can be imposed unless it bears a rational relationship to the person's crime, their likelihood of recidivism, and their rehabilitation needs. So any drug court that has requirements that all participants do certain things that really are not necessarily related to rehabilitation are violating substantive due process. They're doing something for an arbitrary reason. There has to be a particularized inquiry. What does that mean? It means drug courts have lots and lots of rules. We set up rules and we say everyone in our drug court comes in, everybody does 90 days of sobriety house living. Then they all go into intensive outpatient treatment. Everybody has to work in the local chicken farm or whatever, a slaughterhouse. Everybody does this. No one's allowed to have medication assisted treatment. There are these all or nothing rules. Those rules, by definition, are irrational because you are deciding what a person needs before you have actually assessed the person to see what they need. And therefore, everybody getting the same treatment, everybody getting the same supervision is irrational by definition and can be and should be overruled on appeal. There is a requirement for a reviewable record. What does that mean? It means that a drug court judge can't just say, no, the answer is no, I said no, period, move on. The judge must say, why not? And must create something, some kind of a record, some kind of an order, a ruling, maybe a stenographic record, something that explains the rationale so that appellate court could potentially review it. Everything judges do must be reviewable. These things were never meant to be abrogated in the drug court context. On the contrary, they are part of the model. As I said previously, you can, or I believe I said, you cannot require people to waive rights that they may or may not need to invoke in the future. So telling somebody they must waive their right to defense counsel in order to come into the drug court, you could potentially do that. You say, well, we require you to waive your defense counsel right. But if that person is suddenly facing revocation or a jail sanction and says, I changed my mind, I want defense counsel, every appellate court that has considered the issue has said that that right is revocable at will, except to the, that waiver is revocable at will, except to the extent upon which it has already been relied on. Because you can't waive a right that you don't know yet when and if you're going to need it. And so defense counsel waivers are revocable. Equal protection applies in drug courts. That means that not only must we not have discriminatory purpose or intent in the things that we do, but as a result of our best practice standards, which create a higher standard of care and arguably a constitutional requirement, we are required to avoid disparate impacts, whether intended or not. And so if you have a drug court where 30% of people arrested for drug-related crimes are African-American and 5% of people in your drug court are African-American, then you have a burden to figure out where that discrepancy is coming from and what, if anything, that you can do about it. We are not permitted to essentially ignore issues about racial, ethnic, cultural fairness. And yet it is true that drug courts, for the most part, most drug courts do not collect data on this, do not report data on this, do not alter their policies and procedures to ensure racial equity. The result, quite frankly, is that drug courts, although I believe truly well-meaning and having the potential to address racial and ethnic disparities in the justice system, have done virtually nothing to address inequities in our criminal justice system. We say we do, but the research belies our assertions. In fact, we are no better than most other aspects of the justice system, probation, parole, and the like. And in fact, we may even be worse. People may be less African-American, Hispanic people may be less likely to get into a drug court and succeed than they would be on probation or parole, which is why many defense counsel don't recommend drug court to their clients of color, because they just see them as being set up for failure. That's a fundamental mistake, fundamental blind eye that drug courts have turned to probably our most sacrosanct duty. And it's in many respects, in my opinion, it's unforgivable that we have ignored this right. Want to get more into a little bit more away from the legal and constitutional issues that drug courts have unfortunately frequently ignored, but the issue about applying evidence-based procedures in the program. Now, the drug court credo is we treat sick behavior, we punish bad behavior, and we reward good behavior. I'll say that again. We treat sick behavior, we punish bad behavior, and we reward good behavior. That is the fundamental difference between drug courts and just about every other aspect of the criminal justice system. We don't use treatment to address voluntary willful misconduct. Treatment isn't for bad behavior. We don't punish people for intentional misconduct by giving them more treatment or taking their treatment away from them. We also don't forget to reward people when they are doing well. We don't see the criminal justice system as a place where people get punished for doing bad or not punished if they don't do bad. We see it as a place where the criminal justice system actually incentivizes and rewards good conduct. And most importantly, we don't confuse these things. We don't punish sickness and we don't treat willful misconduct. We know the difference. And that's what makes us different from pretty much most other, if not all other elements of the justice system. The first, this was something that was understood in the mid-90s. We understood that when participants had more opportunities to earn rewards for doing well than to earn sanctions for doing poorly, when there was a more chance that I would get positive reinforcement, people did better. And in fact, it was about a 4-to-1 ratio. We've known that since the early 90s. It's been replicated time and time again in drug court programs, although frequently that ratio is in fact inverse, and participants usually have 4 or 5 times more ways to be punished than to succeed in the program. The positive reinforcement does not have to be expensive. In fact, it probably shouldn't be or need not be expensive. It needs to be frequent. Lots of praise, applause, handshakes from the judge, phase advancement, coffee mugs with the name of the program on it, cookies, sobriety chips, those kinds of things with symbolic value delivered frequently. We have known for over 30, almost 40 years now, improves outcomes. And yet to this day, there are many drug courts where basically there are 2 things that can happen to me in court. I can be punished, or the judge can give me some verbal encouragement. And that's pretty much what a typical interaction will look like. And drug courts were meant to broaden that. The biggest distinction drug courts made between our model and everybody else's is the difference between proximal and distal infractions. The single most meaningful difference between drug courts and all other models. Drug courts consider some behaviors that participants are capable of doing. They don't want to do them, they resist doing them, but they can do them if they wish to. And it's necessary to improve their outcomes. We call those proximal behaviors. Most of our participants can tell the truth. They know whether or not they use drugs. They may not want us to know. Their first tendency might be to tell an untruth, to mislead, to obfuscate, but they know what the right answer is. Many of our participants are capable of getting to their sessions. They don't, and they don't want to, but they can if they were properly motivated. For these willful proximal infractions, drug courts hold people accountable by starting our sanctioning about halfway up your sanction gradient. You don't start at the bottom, you start about halfway up, and you build your sanctions up fairly rapidly, so that if somebody's committing the same willful infraction 3-4 times, we are using substantial sanctions to get their attention and let them know that they are required to follow the rules. We do this because the public is also a party to our action and has a right to have its interests protected. And we do that because if you don't deliver meaningful consequences to people for willful, intentional infractions, you create what's called habituation, in which the person says, hey, I keep getting away with it, I may as well keep doing it. And when somebody comes in with higher magnitude sanctions later, that would have worked if you started with it, now it doesn't work either. You have raised their tolerance for sanctioning. So we believe in accountability. That's why we do not adhere to some of the most recent attacks on drug courts under the harm reduction philosophy. Drug courts do use harm reduction services. We absolutely do. We use medications for assisted treatment. We use condom and safe sexual practice education. We use training on effective use of needles, although we don't want them to use, but we do train them on what to do. We accept and endorse Narcan for overdose reversal. Those are harm reduction interventions. What we do not endorse is the idea that if somebody is continuing to use drugs, they're the ones that get to decide whether or not to focus on that in treatment. They're the ones that get to decide what they're willing to do in the course of their treatment. We eschew that as being dangerous and a violation of the public's interest in drug courts, which is that people should be held accountable for proximal willful conduct. We just don't punish them for drug use. We use treatment. And that is what we refer to as distal infractions. some behaviors of our clients reflect things that are too hard for them to do right now. Our clients have a hard time being abstinent when they come into treatment. By definition, someone with an addictive disorder is not going to stop because you threaten them. In fact, if you do threaten them and they stop using, that's how you know they didn't have an addictive disorder to begin with, because the diagnosis requires them to continue using despite punishment. And so it is the people for whom punishment doesn't work. Those are the people who are supposed to be in drug court. And we should not be using sanctions for substance use among somebody who's addicted to drugs. We should be using treatment, because we treat sick behavior. So if we're going to use sanctions at all, they're going to be low-level sanctions, treatment, maybe some treatment adjustments, maybe have them do journaling exercises, maybe have them come to meet with their case manager or do day reporting more frequently, but we are not going to use high magnitude sanctions for substance use. That's the difference. Accountability for willful misconduct, treatment for the symptoms of their disorder. And we know the difference. We do use substantial sanctions, including jail, for willful, proximal, repetitive infractions. That is the drug court model. Now, there are people that would argue, well, we don't know for sure that jail is necessary in that model. And yet the evidence is not as strong as it should be, but the drug court model certainly spoke about the judge's ability to use brief jail sanctions for repetitive, willful infractions. We took a position that what at one time is distal, something that may be too hard for somebody to do when they first come into treatment, eventually becomes more doable for them. So when people come into treatment, it's very hard to resist using drugs. But after they've maybe on medications, maybe they've been working in their counseling groups, maybe they've been getting support in their 12-step meetings, maybe they have been had cravings and withdrawal symptoms are beginning to decline. At some point, they're more capable of reducing their drug use. At that point, what used to be distal becomes proximal and our expectations increase. We do not allow somebody to continue engaging in infractions all the way through. At some point, we expect them to be able over time to address those issues. And so therefore, drug courts have phases. That's why we have phases in a program. It's to tell our participants that what used to be too hard for you, we weren't worrying about that before. Now you're getting better. Now you're clinically stable. Now you stopped hanging out with people who use drugs. You're engaged in pro-social activities. Now our expectations for you have increased. Drug courts talked about phases from the very beginning in the 10 key components. And they said, we don't punish people in phase 1 for doing something that we expect them to be able to do in phase 3. We know the difference between what people can and can't do as they move through treatment. Unfortunately, many drug courts either don't really have phases, or if they do have phases, they mark them by days. So they say the phase 1 is 90 days, phase 2 is 90 days, phase 3 is 180 days, phase 4 is 90 days, and they add these up for the length of treatment. Well, some people won't need 90 days to move from phase 1, where they're becoming clinically stable, to phase 2, where they're capable of abstinence. Some people can do that in 30 days. Other people may need 4, 5, 6 months to get there. So we need to be moving people through the phases based on our assessment of their ability, not our predetermined lengths of these phases. And unfortunately, many drug courts really don't keep track of when somebody has mastered the goals they needed to master in one phase to be able to move on to the next. Jail is detox. Drug courts do not use jail as detox. Drug courts do not use jail as housing. Drug courts do not use jail as treatment, because we don't use punishment to address sick behavior. We use punishment to address willful misconduct. And the use of jail and calling it treatment doesn't make it so. It is a fundamental violation of the drug court model. Now, some people are going to push back immediately. I'm sure I can hear the groans from the audience. Well, what if somebody is testing positive and they have fentanyl in their system and they're going to overdose on the street and we can't find them a bed. There's nowhere for them to go. In a situation like that, which should be relatively rare, should be infrequent, the judge needs to make a finding, because what we're really talking about here is involuntary commitment. That's what you're really talking about. Or preventive detention. That's what you're talking about, not a sanction. Under such circumstances, the judge needs to make a finding that the participant is an imminent threat to themselves or others, not just could be, drugs could wind up doing something to them, but the facts of this case make it likely that this person is going to potentially overdose in the near future, and that there is no less restrictive thing we can do short of jail to protect them during that emergent crisis situation. And as soon as that situation changes, the crisis has declined, they must be released. That's the only way that a drug court model really is following the model itself, which does not believe that jail is a therapeutic institution. It isn't. Now, I hear all the time, well, our jail has a treatment unit and we have a very progressive jail, and the jail does not have clinically meaningful impacts, especially when compared with outpatient treatment, which is where the client is in your drug court. They're an outpatient treatment, which is generally as or more effective, certainly over the long term, to step someone back to jail, as opposed to maybe or perhaps a residential program, is a violation of the model. Treatment. It was always understood in drug courts that treatment needed to be matched to people's treatment needs and to their criminogenic risk level. The whole idea of risk-need responsivity was understood in the very early days of drug courts, and we were going to take people's criminogenic risk, the likelihood of committing another crime, the likelihood of failing on community supervision, the likelihood of dropping out of treatment was part and parcel of their treatment plan, because there was research showing that. Therefore, we don't put everybody in the same intervention to start. We don't start a drug court where everybody is in intensive outpatient treatment and then goes to outpatient, because some people may need residential treatment. Some people may not need intensive outpatient treatment. So we will base this on an assessment of their actual needs. Our treatment providers were supposed to receive specialized training for criminal justice populations in drug courts. Just simply sending people to the treatment system as it currently operates is not sufficient, because most people trained in sort of traditional treatment methods are not trained in the management of criminal justice populations. Many don't understand risk-need responsivity, and this is not me saying this. This is studies that have found where they rated treatment programs working with drug court participants on their awareness of and adherence to risk-need responsivity, rated 68% of the programs as unsatisfactory, meaning not following the practices to a minimal level, and about another 20-odd% needing improvement. So that in fact, treatment providers in these programs didn't know how and don't know how to work with high-risk populations. As a result, they are mixing high-risk and low-risk people in the same treatment groups. It has been shocking to me how unwilling many treatment programs have been to stratify their groups by risk level, despite the fact that research shows that you harm low-risk people when you mix them with high-risk people. So they need training. They need a continuum of services. Now, not all programs have this available to them, but ideally they would have a continuum of services available from intensive outpatient, residential, and the like. There are some programs, some drug courts that say if participants need residential treatment, then they go there instead of drug court. There's no, that's not an either or situation. Somebody should be able to be in drug court and receive residential treatment while they're in the drug court. A phase structure for complementary services. I said earlier, we take people, our first phase is focusing on stabilization. Then we're focusing on our intensive substance use treatment. And then we're transitioning people to long-term recovery-oriented services when they leave the program. This was all discussed in the original 10 key components of the drug court, but is starkly absent from some programs. The centralized role of the clinical case manager. At the time of drug courts, there was something called TASC, Treatment Accountability for Safer Communities, TASC. These were people who were trained, clinicians, trained in how to do risk need assessment, develop case plans based on people's risk and need profiles, monitor how people were doing in phase 1, and let the team know when they're ready to move from phase 1 to phase 2. And if somebody's in phase 1 and they have a behavioral lapse that violates something that they're not yet ready to do, it's this case manager's responsibility to tell the team that. The expert in what's proximal or distal for participants, the expert in what phase they're supposed to be in. And unfortunately, I would say probably the vast majority of drug courts, there is no such person working in the program with specialized training in TASC or some other form of evidence-based clinical case management for criminal justice involved clients. There are some drug courts where probation does it, and they are basically managing the case and the technical case plan, but they're not managing the clinical assessment of participants in terms of risk reduction. There are others where treatment providers are doing it without the training on accountability and risk reduction that's required. And there was supposed to be proactive information sharing. 42 CFR, HIPAA does not prohibit treatment agencies from sharing information with the criminal justice system. It does not prevent that. It says under what circumstances it can be provided, what privacy releases are required, what limitations on relevance and scope, limitations on redisclosures after the first disclosure, make sure the recipient doesn't disclose again. So there are limitations on that, but not on information sharing. Drug courts are a team-based model. And to this day, we're still struggling with some members of the team not sharing information from their perspective on how participants are doing. The multidisciplinary team. Judge, prosecutor, defense counsel, treatment, probation, law enforcement, at a minimum, are the minimum members of a drug court team. Judge, prosecutor, defense counsel, treatment provider or treatment representative, probation officer or probation representative, law enforcement. That's at a minimum. And if any one of those people are missing from a drug court, the average effectiveness of the program is cut in half, 50% less effective. Therefore, any program that doesn't have these people on the team is violating one of the key components of the drug court model. I would point out to you that the defense counsel and prosecutor have their own key component. There is a whole component dedicated to the role of defense counsel and prosecutor. So if you don't have a defense attorney or prosecutor on the team, it's hard to understand how that you would actually be a drug court, because those are considered essential personnel. As I said earlier, defense counsel waivers are generally revocable at will, unless they've already, to the extent they've already been relied upon. All members of the team are supposed to be sharing information with each other, communicating with each other, making recommendations, and engaging in shared decision-making. That doesn't mean the team votes as a team. It means the team gives its best recommendations to the drug court judge, who ultimately, based on all that team input, makes his or her decision. And all members of the team are involved in responses to participant compliance. Everybody on the team is an expert witness, essentially weighing into the court on their recommendations for consequences for how participants are doing. So any person who refuses to participate in those conversations, who doesn't show up for team meetings, is in fact undermining not just their own role, their own function, and violating their own, frankly, ethics in the context of a drug court, but is undermining the effectiveness of the entire team and cutting that effectiveness in half. Team meetings and status hearings, all team members are expected to be regularly present for team meetings. It could be online or virtual, but team discussions prior to court hearings to discuss how participants are doing, give the judge the information that he or she needs in order to make an informed decision, and make recommendations to the judge about how the person thinks the judge should respond. Ultimately, the decision will be the judge's, but all team members should be weighing in on this information. Self-learning, self-correcting. Two of the standards, two of the 10 key components are dedicated to ongoing professional program evaluation and continuing education. So 20% of what you're supposed to be doing is continuing education and evaluation of your own work. Measuring performance and outcomes, measuring what you do and how it's working, is a substantive element of a drug court. In other words, it's not, here's the drug court model, now you should study it. It's studying it is itself the drug court model. We believe that we should be measuring what we do, seeing if it's working, and improving our outcomes. We do this because, to recall, at the time that the 10 key components were first created, the big issues of the day, especially in industrial organizational psychology and in business management classes, was all about continuous quality improvement, continuous performance improvement, where programs monitor what they're doing, see if it's working, and make changes in a routine, ongoing fashion, constantly seeing how to improve themselves. And so that was adopted in the drug court model as a key component of the model, that we are not, we don't remain the same from the day we started, that we would have to have annual continuing education. What we know is that if you were to take a test before this training on, what it is to be a drug court, and then took us the same test after this training, hopefully you would score better. Then if I gave you that test again a month from now, maybe you might start to get some more wrong again. 2 months from now, 3 months from now, 6 months from now, at some point, your scores begin to decline where they're not all that different from where you started, because we just forget about things. How long that takes generally ranges from 1 to 3 years. And so therefore we basically say, and the best practice standards say, that we should be getting our education annually, but certainly no less frequently than every 3 years. Because if you also consider the fact that drug courts were always learning new information, if you go to a training and don't go to another training for 5 years, not only are you forgetting what you learned before, but you're not learning any of the new information. And so you wind up being sometimes a decade or two behind effective knowledge of best practices. And that's basically been our experience, that there are many drug courts out there functioning at the level of what was considered best practice in the 1990s or early 2000s, and is really no longer considered best practice. And those programs are still locked in those sort of historic ways of doing business. So to close out, and then we'll take hopefully time for Q&A, just some questionable drug courts, some examples out there of practices that we see fairly commonly, fairly routinely. I'm not saying the majority, I'm not saying all, I'm not saying necessarily most, but we see it out there. These things are happening, and they really raise questions about whether this is a drug court. Programs that are managed by a community panel. There's a number of juvenile drug courts in which program personnel don't want to treat the kids like criminals. They want to normalize the experience. And so they have them meet before people who are volunteers, work in the community, and the judge backs them up, but their person is not meeting with the judge frequently. There are programs in which the judge plays a subsidiary role, and most of the care, most of the decisions are managed by the treatment agency or by probation. Certainly in the federal system, there are many drug courts in the federal system that are really probation programs with the judge backing up probation. There are some programs that are police supervision, police diversion programs. There are programs that are school diversion programs for truant, that kind of thing, prosecutor diversion programs. These are not drug courts. A drug court is a court. It is a condition of sentencing. The judge is in charge of the intervention, status reviews in front of essentially a large body of witnesses, the use of formal procedural formalities lessened to the extent that they can be. That's the model. There are some programs that review participant compliance individually because they don't want to embarrass them in front of other people or outside of the courtroom. Courtroom is theater, public forum, the public record is a key component of the model. So treating it as if trying to make this not be a court because it makes you uncomfortable to have it be a court is not the model. Now, I will remind you that drug courts are for high risk, high needs people. So there are many people who shouldn't be in court, but they shouldn't be in drug court anyway. There are many drug courts, unfortunately, where participants generally, when you go to court each day, there are three things that can happen to you. You can be sanctioned, you cannot be sanctioned, or the judge can say, you're doing a good job, keep up the good work. In other words, the best thing you can hope for is not to be sanctioned and maybe some words of encouragement. These drug courts have missed the point of copious, low dose, positive reinforcement. There are drug courts that use jail sanctions for substance use prior to clinical stabilization. Participant has a positive drug test, they get a day in jail. They have a second positive drug test, they get 2 days in jail. They get a third, they get a week in jail. Those are not only not drug courts, those are the antithesis of drug courts. Those practices are what drug courts came to stop. If jail stopped drug use, we wouldn't need drug courts. That's what we were always doing. Drug courts came to use jail only for proximal, willful, intentional misconduct and to use treatment outside of jail for people's clinical disorders. This means that if you're treating a patient with an opioid use disorder and that patient is still suffering withdrawal symptoms, cravings for opioids, loss of control over their opioid use, anhedonia, the inability to experience pleasure, depression, and they are feeling compulsive need for that drug, and you impose a jail sanction or some other type of sanction on that person for continued drug use until they have been stabilized, and in that case, it's going to mean medication stabilization, you are violating the whole raison d'etre of drug courts. You missed the whole point. And I'm afraid that that is not as unusual as it should be. If you are using jail and calling it detox, calling it treatment, calling it housing, calling it these things without limiting it to only dire circumstances where there's no less alternative available, again, you are basically bootstrapping the old model of which jail was used as if it were treatment when it isn't. That is not the drug court model. If you are too lenient and let people get away with not showing up for sessions, if the judge is always falling for every excuse the participant offers, if the judge or treatment team doesn't believe in high magnitude sanctions and basically focuses on positive reinforcement exclusively, then I hope you're treating very low risk people for whom that might be appropriate. But if you're treating a high risk population, you are threatening that not only their own treatment plan, their care, but public safety in your program. Drug courts that don't have a defense lawyer or prosecutor on the team. It's hard to understand how a program could be a court. It's a drug court, how it could be a court without representation on the team. Participants are required to waive defense advocacy to enter the program. Would basically be inconsistent with the drug court model. Team rarely meets before court, or the team basically does most of its discussions, gets most of its information during the court hearings. Purpose of drug court was for the team to figure out all the uncontested facts, understand what's going on with the person, and get everybody's input from the team so the judge could then go in with an informed ability to interact with the participant and participant's counsel. The judge would have already information, wouldn't go into court and try to learn the information in court, might confirm any disputed facts, but the purpose of a drug court is to do the intervention, is to respond to behavior, not learn what behavior to respond to. And so teams that don't prepare the judge ahead of time really don't function like a drug court. If you're not offering participants a due process hearing before either revocation from the program or a jail sanction, any loss of liberty interest, the person should have a due process hearing. That does not mean a whole new hearing scheduled several days out with a stenographer. Very often that hearing can occur in the context of a status review, but it does mean the participant knows in advance so he or she can prepare. Their defense counsel can prepare and be present. The participant has a right to make their argument, and the judge has a duty to explain his or her decision in how the judge resolved contested facts or contested matters. Any drug court that has a blanket prohibition against a treatment known to be effective, for example, medication-assisted treatment, is basically undermining the very basic notion of a drug court. The 10 key components talk about buprenorphine and methadone in the 10 key components. If you don't believe me, go look. We always adopted evidence-based treatments, not the beliefs of criminal justice professionals. We came into being to replace beliefs with evidence. And if you are treating people with opioid use disorders and denying them medications, you are violating the sanctity of the drug court model. If participants in the program are not related to, if the requirements in the program are not related to each participant's specific offense, rehabilitation needs, public safety threat. In other words, developing individualized case planning, as opposed to requiring everybody to do the same thing, that is a violation of the treatment components of the drug court model. And if you are not currently and reliably measuring what in fact you are doing, what services do you in fact provide, what outcomes are you in fact producing, and are those access and outcomes the same for members of suspect classes like persons defined by race, ethnicity, gender? If you are not measuring that, ensuring that you are providing equal protection, you are violating some of the constitutional obligations of a drug court. I'm going to stop there because time is short and we only have time for a few questions. I'm going to turn it back to Shane. And Shane, you can work from the, did I already take it away?
Nope, I am here, so you are good. So we do have a couple of questions. One question looks at for phase time. Should we still have a minimum number of days for each phase? Like to hear a little bit more about advancing participants who master the phase goals.
Okay, so the minimum length of a phase should be the minimum length necessary to demonstrate, in fact, that the person has mastered the behavior. And so what that means is, how long does somebody have to be clinically stable in phase one with no withdrawal, no cravings, no anhedonia, before you can feel comfortable that they're now capable of paying attention in their counseling groups? And so there's no one right answer, but generally you'll see people arguing somewhere between 30, 60, maybe 90 days. And so what you might want to say is that in phase one, participants need to demonstrate a minimum of 30 or 60 days of clinical stability before we start punishing them, sanctioning them for not paying attention in their counseling groups. And so it's not that the phase is a minimum amount of time, is that the participant demonstrates mastery by showing that they can or don't do something for a limited amount of time. So it's still a mastery criteria. So some programs will say phase one is a minimum of 90 days. Well, why? 90 days, what's supposed to happen in those 90 days? So what you really want to say is, in 90 days, the participant has given me 3 months where they're clinically stable, they're making it to all their appointments, and they're being honest. That's phase one behavior. I mean, you have now accomplished a great deal. If you can clinically stabilize a high-risk, high-needs participant, get them to be honest and get them where they need to be. If you can do that for 60 days, have a big applause in the courtroom, lots, cake to celebrate, and move on to phase two.
Great, thank you. And we can probably answer this one more question. What options does a team have for clients who continue to relapse as they go through the phases?
So what I'm not sure I understand the question. If somebody is in the early phases of treatment and you're using non-high magnitude sanctions, then basically it would be either not sanctions at all. That's where you do treatment adjustments. So the person continuing to use drugs, the question is, why are they still using drugs? If they're still using drugs because they are suffering withdrawal symptoms and cravings, then you put them on medication-assisted treatment, or at least recommend it to them, have them evaluated. If they're doing it because everyone in their house is using drugs, then maybe you need to find safe and sober living, or at least have the person do day reporting at the program. If you're trying to figure out what's going on, maybe you have them do a journal exercise or set up an activity schedule. So these would be your lower magnitude things that are treatment oriented. As you start moving up and the behavior becomes proximal, then you might start doing community service or jury box observation in the courtroom, or day reporting, going to a day reporting center. These would be short of jail sanctions. So if that's the question, there are on NADCP's website, or there used to be at least, lists of incentives and sanctions categorized by low, medium, high magnitude, which if you're looking for ideas, that's where I would go.
Definitely.
I have those lists as well, if anybody wants them.
Right. Now, I'll admit I haven't revisited those lists. I created those probably 10 years ago. So it may be that we should probably revisit them and update them. But there are many things that people can be doing. And those lists include incentives as well, because I really think that we have lost track of the importance of reinforcing good behavior as being as or more important than sanctioning undesirable behavior. I think we've lost that way.
Definitely. Well, thank you again so much, Doug. We are out of time and ready for a break. So been very informative, and we appreciate you taking the time with us this morning. Everyone, we are going to be back at 9:15, where we'll start up with our last session for the day with Terrence Walton. So thank you again, Doug, and see everyone in 15 minutes.
Bye, everybody. Thank you.
Welcome back, everyone. Hopefully everyone had an opportunity to stretch your legs and to move around. We are excited to have Terrence join us now for our second presentation of day 2. Jeff did send out the PowerPoint or the presentation so that you have a copy. So if you are wanting to follow along or have a record after the training, you should have that in your email. Terrence is the Chief Operating Officer for NADCP. He is among the nation's leading experts in providing training and technical assistance to treatment courts and other providers of substance use disorder treatment. Prior to being named COO in 2015, he was NADCP's Chief of Standards. Mr. Walton is an internationally certified alcohol and other drug use counselor with over 25 years of experience helping individuals and organizations champion positive change. Please, everyone, welcome Terrence Walton.
Well, thank you, Shane, and good morning, everyone. It is so good to be with you, or kind of with you. I'm looking forward to getting to Montana in person whenever the world lets us do that. It is my honor to be here today, and I know you just heard from Doug, and you're pretty clear about what it takes to be a drug court, and I am looking forward to this presentation because let's face it, we all understand that that helping a person to find a new life to stop using is tough work. It's tough work on us, but it's especially tough on them. So it's tough work getting people to stop, but the real work is getting people to stay stopped and helping them to not be miserable in the process, to actually find a fulfilling life without the medication, without the, and I mean that in a theoretical sense, but without the relief that comes, an escape that comes, at least at the beginning, from substances. So I am honored to talk about this today. This is, listen, you all, if you know me, you know that while, my job is to know about all things drug court, there is nothing I care about more than treatment and recovery management. It is, aside from being sure my family, my wife, and my 2 small children are well and know how much I love them, my reason for being on earth is to help men and women break free from addiction and stay that way. And for most of my career, that has been about helping people who are helping people break free and stay free. So it is my honor, and I thank you for allowing me to walk in my calling by being here in such large numbers today. This matters a lot. We're going to spend the next now 58 minutes focusing on recovery management and narrowly and particularly on how once people begin to make progress, once they begin to get a taste of wellness, how we can help them to stay on that path, and if they get off that path, to get right back up. So let's start with this. Before we talk about, you can't really talk about relapse or recurrence without understanding addiction and recovery. So the American Society of Addiction Medicine in 2019 came up with a new definition for addiction that I love. And they describe addiction as a treatable chronic medical disease that involves complex interactions between brain circuits, genetics, an individual's environment, and their life experiences. It goes on to say that people with addiction use substances or engage in other behaviors that often that become compulsive and often continue despite harmful consequences. I could spend this whole hour dissecting with you that definition, but we don't have time for that. But I think what I like most about this is lots of things, but I like the fact it doesn't pretend this is simple. It makes it clear that yes, addiction's about the brain, but it's also about lots of other things that both are precursors to addiction and are impacted by addiction. It also makes the point that this is chronic, and that means it is prone to recur. It is prone to relapse. It doesn't always happen, but it's a part of the process. And so smart treatment courts and treatment court practitioners don't pretend that's not the case, that we are intentional, deliberate, systematic and science-based about helping people prevent recurrence, prevent relapse, and I'll be using those terms interchangeably, relapse and recurrence, helping them prevent that, to see that when it's coming and interrupt it before it happens, but also helping them to respond appropriately if it happens. Both things matter. I also like the fact that this definition begins with hope. Begins by indicating that addiction is treatable. And it may not always feel like that when you're living it. People who have tried over and over again and failed over and over again, who got, this good, good abstinent time under their belt. They were doing well for weeks and months, and then they messed up again. They can begin to feel that even if it gets better for a minute, eventually I'm gonna mess up. That's a kind of hopelessness, a kind of lack of self-efficacy that can get in the way of people getting better and can create a self-fulfilling prophecy. And I don't have time to talk about hope and hopelessness. I'm gonna do a whole new presentation on that sometime in 22. But there's two kinds of hopelessness that we have to confront in addiction and in treatment courts when trying to treat addiction. One is the hopelessness that I just described, that they don't think they can do it, a lack of self-efficacy, that their life experiences told them, and maybe what they've seen from those around them in their real life, it shows them that, I really won't be able to get better, not for long. But there's another kind of hopelessness that is more subtle, and that is the fear or belief that even if I get better, my life won't really be any better. Even if I manage somehow to stop using drugs, stop drinking, get out of trouble with the law, that my life still won't be any better. I still won't have a fulfilling life. Both of those kinds of hopelessness can sometimes stop people from getting better, and can also lead to recurrence or relapse, including not just falling off the wagon and getting back on, but prompting them to conclude they can't do it and give up. So I want you to keep that in mind as we begin, that you are wise to be here in such large numbers, because we got to get this part right if we're going to successfully treat addiction and help people to manage their own recovery for the long term. So here's the big picture. We know there's an assessment in our environment. Now, there's been a screening ahead of time. There's been a legal screening. There's been a clinical screening. But things for those who end up in drug court, the real juice begins here with a good assessment. I'm referring to a clinical assessment. We know there's already been or will be some kind of risk assessment too, but I'm referring to a clinical assessment to really assess the extent, scope, and other details of their substance involvement or mental health issues, and to help chart the course for how we begin trying to help them in a professional way. Sometimes out of that assessment, some urgent needs are identified, things that are critical. Maybe the person is in the midst of withdrawal or at high risk for that. Maybe they are homeless or in some dangerous environment. There might be some urgent need. Maybe they're assessed to be at high risk for overdose and death, and therefore need to be immediately assessed, considered for medications, whatever it might be, that after the assessment, treatment court placement happens. But sometimes, especially if there's any span of time between when a person is assessed and when they get in treatment court, that sometimes needs need to be addressed right away. I mention that because we don't say that enough. And I want the treatment folks who are with us today to recognize that even if we're assessing for the purpose or screening, whichever you do before you get into drug court, if we're screening or assessing for the purpose of determining drug court clinical eligibility, that if you identify urgent critical needs, you may need to make connections to address those immediately, even before they're officially placed in treatment court. And then we begin the work of treatment in all its facets, helping people develop the motivation, the insight, and the skills it'll take to initiate and maintain a substance-free life of recovery in all its facets. We're not going to talk about all those facets today, but we know that's part of how this all works. And what it really is about, helping them, especially at the point that they conclude, yep, not sure if I can, but I really need to change. Not just because the judge wants me to, not just because I need to get out of trouble, but I really need to get well. Now, it's perfectly okay if when they enter treatment, that's all they're there for, just to get out of trouble. That's a good sign. I've worked with many individuals who were given the option between jail, or treatment, and they said, I'll do my time. So I've always believed that it is a good sign for a person who decides, even if they don't think they really have a problem, and if their full intention is to go back to using when they get out, I consider it a good sign that they choose this and decide to show up, and I tell them that. See, whether you're serious or not right now, whether you actually have discovered whether you need to change or not, that you showed up and chose this is a sign that you're making some good decisions, even in the midst of everything that's going on. But at some point, that motivation needs to become internal. And then we begin to help them manage recovery. At the point that they begin to say, okay, I really want to try to make this happen. And that's what it's about. It's about how do we help them to manage all that must be managed for people to move from active addiction to lasting recovery. And in that process, somehow, as they make progress in managing their recovery, at some point, they complete our program, the treatment piece, and eventually the full drug court. But that really isn't the end of our responsibility. That what we want treatment courts in 2021 and beyond to understand is that there's good research that suggests that if we have a way and the means to continue some contact with participants, even if it's by telephone after they complete, just to check up on their recovery, to see how they're doing, that can make a big difference in outcomes. Doesn't have to be, it might be a monthly check-in by phone that we initiate, that they agree to ahead of time. For some people in some programs, they are still under supervision during this period of time, even though they finish treatment court, sometimes not. Regardless, that we make it a part of our program, and tied to that is if they are in trouble and if they need a connection, if they need a brief session to help stabilize and help them get on the right path, that happens. If we can find a way to do that, we are going to significantly increase the likelihood that people will get better and stay that way. We just added this last portion because we really want treatment courts to understand the importance or the potential of really making a big impact by adding some model of recovery checkup after the person completes. Figure out what you can do. I don't know the details, but I understand that there's an announcement out there offering money to treatment courts across Montana, up to $5,000 to, you may have talked about this earlier with Doug or whatever, to do whatever you want to do to enhance your drug court, including if you want to try a way to be able to afford to do some recovery checkup, whether that be with a staff person or a trained peer mentor, recovery coach, or whatever. You use other stuff. You can use it for other stuff as well to enhance your program. But whatever it takes, it can be a best practice in helping people to get better. To get that checkup, sometimes folks can let us know that they need help. I want to make this point really clear, so I put it all by itself on the slide in big print. Relapse prevention, recurrence prevention is recovery management. It really is. That, yes, it is okay to develop interventions and focus on, okay, what does it take to help people avoid relapse? What we're really talking about is how do we help them to initiate recovery? How do we help them to manage that recovery once they've initiated it? All the things they have to change and keep doing and then adjust, and how does all that look, and how do we help them make sure they have the right connections in their life to stay well? How do we help them find healthy ways of managing stress? How do we help them find ways of dealing with situations that they can't change right now without resorting to substances to help you escape? How do we help them to navigate the normal ups and downs of every life? A life in recovery or not, a life for a person who has lived with addiction, a person who hasn't. How do we help them to navigate that in a way that allows them to continue to be on the path of wellness? And ultimately, how do we help them to maintain their recovery for the long term? So when I'm referring to relapse prevention or recurrence prevention, I'm talking about recovery management, helping them to do that in all of these three areas: initiate and maintain, manage. And in practice, that was sometimes helpful for me when I began thinking about it that way, because sometimes I've run into clients, and some of you have as well, and they were clients to me because I'm a clinician, but I've run into people who I was treating who, they were so done with addiction. For them, the party was over. The party had ended long ago. And at the point they actually got some control and was able to live without decisions driven by a compulsion to use, they didn't want to ever think about using again. And unfortunately, they kind of had to. Part of good recurrence prevention means you begin to think about, as well as I'm doing now, like if I were going to mess up, what would that path look like? Like what are the things around me that are threats to my recovery, or the things inside of me? You gotta think about that, even if you don't want to. And so sometimes when I ran into a client like that sometimes there are people of faith, like I am. I'm a person of faith. I'm a religious man. And sometimes people of faith say, oh, no, that's not faith. I'm not talking about using because I'm not going to use, and I'm not making light of that. I get that. But you kind of got to. And so I would say, well, let's figure about relapse. Let's just focus on how you're going to manage your recovery, even on days when you don't want to be recovered. Because there are days you're not going to want to do all this. You're not going to feel like it. That's just how it is. How are we going to help you to manage that so you don't lose what you've gained? Relapse prevention is recovery management. An early point I want to make is that it is absolutely true that in good relapse prevention planning, it involves identifying triggers, as I'll talk about later, and avoiding certain things. I am not of the school of thought that says the best way to break free of addiction is to purposely expose yourself to triggers and then don't give in to the craving, and then eventually that'll be extinguished. Now, that is theoretically correct in behavior modification, but I also think that's foolishness, that, deliberately exposing myself to triggers and then using the skills I learned to not give in to that craving, and therefore that strengthens me. That's really reckless, because life all on its own is going to give every person seeking recovery a ton of triggers inside and outside over time. We don't have to manufacture that. It's a best practice for getting better to avoid high-risk situations when you can, to avoid those things are triggers. And effective relapse prevention in treatment courts and anywhere else involves helping people to think through and identify those scenarios, those situations, those feelings, the need to medicate, the desire to celebrate, whatever it is, identifying those and finding, first of all, how I can avoid those things. And then when they occur, how I manage them and respond to them in a way that doesn't lead to use. That's a part of it. But, it is, a life in recovery. Good recovery management isn't just about avoiding stuff. It's not just about saying no and finding ways to say no. It's so much more than that. If that's all it was about, it would might look kind of like this. A series of don'ts. Be careful. Don't stop. Wrong way. Stinking thinking. People, places, things. Now again, not making light of that. And when you try to come out of addiction in your early recovery, you better be avoiding some stuff. But life has to be about so much more than that. None of us, addicted or not, could be happy with a life where what I'm doing is always running from something. We have to be moving towards something, finding some purpose, some destination that's different and better than where I am now. Good recovery management planning, good relapse prevention planning is always replete with things I'm going to do, not just things I'm going to avoid. People are not likely to give up something for nothing. And what people got and get out of drinking and drugging is something. They're not going to give it up for nothing, but they might be willing, because it starts with willingness, even before commitment, might be willing to give up something for something better. And part we do is help them see that and practice that. Recovery is broad, not narrow. It opens the world, doesn't narrow it, but it won't seem like that. An effective treatment, recovery management, and recurrence prevention is helping people see what their possibilities are, helping them to learn and practice new things, including ways to have fun, ways to let your hair down if you have hair, ways to enjoy life, and ways to keep yourself safe and well. In fact, if I approach this intersection right here, for real, like I don't know who created this little picture here, or I'm certain it's not a real thing. I hope this isn't a real intersection, but it kind of look real. But if I approach this intersection for real, I wouldn't know what to do. Stop, wrong. I wouldn't know what to do. I'd either stand still or wait. I don't see a sign that says no U-turn. I just had to make a U-turn and go back to where I came from. And that's not what we're trying to make happen. Good recovery management planning is about what I'm going to do every day and regularly to stay well. I will use the term recurrence and relapse interchangeably. Relapse, while it's not stigmatizing, in some studies they've shown that the term relapse is more likely to, it's less negatively received than the term recurrence. I use them both interchangeably. So recurrence, in one definition, is a process, and that's important. It may seem like it just happened all of a sudden, impulsively out of the blue. That's certainly not the case when it's a true recurrence. When this person was actually in recovery and they actually returned to use, that's a process. The process might happen quickly or it might be dragged out over time, but it's always a process. That's good news. It's a process, and we can train individuals to recognize when they're in that process, it can be interrupted before things go left. A process of a recovering person's return. And I want to emphasize that. I mean, there's lots of use that happens in treatment courts as people are trying to get their act together. And there's lots of new use where a person has produced a number of negative UAs and then they get a positive. That happens a lot. But not all new use is the same. And recurrence or relapse occurs for a recovering person when they have, returned to the self-prescribed non-medical use of any potentially intoxicating substance and the reemergence of symptoms of substance use disorder. So there's a lot there. Now, a person using medications for addiction treatment or medications for mental health disorder or medications for high blood pressure is not inconsistent with recovery at all. That is not the same. This is individuals who are taking on their own something to get high. And for it to be an actual recurrence, a recurrence of substance use disorder where the person was in remission, they were diagnosed accurately with a substance use disorder in the previous 12 months or so, 12 months, outside of a controlled setting, and they achieved recurrence where they had virtually no symptoms for from 3 months up to a year or longer, and then they return to use in this model, return to use, and symptoms reemerge. There are 11 criteria of substance use disorder. They begin to develop symptoms again. That's a recurrence. Both of those things. If you have any questions about that, check those in to Shane, and I'll respond to those in writing to you, and Jeff will send all my responses to everyone's questions to everyone after the training. So for the team members for everyone, if you're a clinician who are making these calls, who have to answer certain questions, and for everyone else, there are two big questions you ought to have whenever there's an episode of use in your program of substance use, whether it's self-reported use or use you discovered because you are doing the right thing, you are testing randomly and regularly throughout your program. The first big question you ought to have is, so is this a recurrence or continued use? Is this a relapse or continued use? And here's what I mean by that. So there can be a person who struggles in the program at the beginning to achieve abstinence as demonstrated by negative urines, and then they start getting some negative urines, and then they get a positive. Now, is that automatically a relapse or recurrence? Maybe not. Maybe when they were, those negatives they got, really, it's just a part of their pattern of use. Some people, when they are living with addiction, use every single day. Others, they might use every day, depending on the substance of the person, or they may use at certain predictable intervals, maybe every weekend, or perhaps they have this pattern they've always done where they will use for a period of time and sort of take a little break and then get back to use. But their lack of use isn't about commitment. It isn't because they are working recovery. They just found ways not to use. It's a different thing. That's continued use. It needs to be responded to. We can respond to that clinically. We got to know, was this person in recovery, active in recovery, doing the things of recovery, not only because they wanted to get out of trouble, but also because it became personally meaningful to them. And then they returned to use. That's a recurrence. That's a relapse. And we respond to that clinically differently than a person where we're still kind of at square one. We're still trying to help them become committed. We're still trying to help them establish a pattern of abstinence and recovery supportive actions. We're trying to help them find personally compelling reasons for a new life. We're trying to help this matter to them. It's no less treatable, but we treat it differently. If you have any question about that, any question about this first big question, chat that in. I'll say more about it. So there's two questions. First one is, so is this an actual recurrence because this person's in recovery, or is it continued use? There's a second big question though, and that is this like just an episode of use, or like what we call a lapse, or is this an actual recurrence? Is this person now symptomatic again? Are they now compulsive again? Is this substance use now interfering with life? Are they back in active addiction? Different things. Both very treatable, but we respond to them differently, clinically, without a doubt, and probably otherwise as well. So once again, so there are three categories of new use. One is continued use. That means even if that person was on a break, they weren't in recovery. Their resumption of use is acting just their continuing pattern. Or maybe there was no break in use. It's just every time that they have consistent positive urines. Those aren't relapses. That's continued use. It is treatable. We have ways we respond to that in treatment, but it's different than someone who was in recovery, who is in recovery, and they use again. Maybe it's an episode of use, or maybe it's worse than that. Maybe it is now use that is recurring, and not just using again, but they are now becoming symptomatic again. There are 11 criteria for substance use disorder. For a person to have even mild SUD, they must meet at least 2 of those criteria. For a person to be in remission, they meet, they can have virtually no criteria. They might still have cravings sometimes, but the other criteria not. And then for some, when they return to use, even if it was just going to be a lapse, they become symptomatic again. They become compulsive again quickly. It's not one episode of use. Now they are back using again. It's different than a lapse. All treatable, but different. And the clinician's job, the treatment professional's job on your team is to make an assessment of what happened here and to help advise you, because they're going to be able to give you a sense of, okay, here's what we think this is. Here's what we're going to try to do here. And you find out for them, how can we help? Sometimes a sanction, especially if any one of these is also connected to certain willful behaviors, like skipping out on groups and violating stayaways, going to risky places they were supposed to avoid, and all kinds of willful actions. A sanction may be very helpful in addition to a treatment response. Sometimes a sanction is not necessary. The treatment will respond to it. The court will admonish them, let them know this is serious. I need you to work with your provider. We are patient with you. We understand addiction, but you got to get better. You can't continue to test positive forever. So I need you to go all in with your treatment counselor and figure out how you can get well. And then that's responding. So it does matter what the episode of use or new use means, because there's another category that I kind of made up. This is part of recurrence. Sometimes it's not just lapse, it's not just relapse, it's actually collapse, where the person gives up. And all of those people, we can't find them for a while. They've gone AWOL. They've given up. And we really got to try to avoid that, because those are people we sometimes lose, and lose for real. Quick summary, a little more detail, right? Continued use for the person in that category. If this episode of use or resumed use is just a part of their pattern of addiction, they're not yet committed to recovery. They're not in recovery yet. They may be ambivalent about either their need to stop using or their ability to stop using. And part of what we do in treatment is trying to assess that and help to raise their commitment and willingness level, help them become more committed to it, helping them to see the importance of making changes, and then helping them develop the skills to be able to reliably achieve abstinence and to believe that they can do it, to have the confidence it's possible for them. Sometimes when you see sort of these string of negative urines that really don't mean this person's committed to recovery, it may be what I just made up a term that I call circumstantial abstinence, where they're able to do so either because they're locked up and it's less convenient to use when you're locked up, it's more expensive, less accessible, or maybe they're in residential treatment and but they're just in there doing time. They're not really working on recovery because they're there. It's a controlled setting. It's easier not to use, and then as soon as that's gone, they go right back to it. Now, sometimes that happens anyway, even if they were in recovery, but there are instances where a person is doing time in residential, not doing treatment, and when they return to use, it really isn't a relapse. It isn't, I was committed to recovery, making progress, and lost it. They never really had it. And that's not something you're going to be able to assess from sitting behind the bench or behind your desk. That's something that takes clinical expertise, and even then it's not easy, to look at a number of factors, to talk with them, to do sort of an autopsy on the use incident to see what led to it. Most clinicians who've had some time to work with this client will have a sense of what the new use means, and you need to know that. Sometimes the person's found a way just to white knuckle it. You know, I used to call that being a dry drunk. I've known people throughout my existence that was the case. They wasn't using, but we kind of wish they were, because they were miserable and made everybody else miserable too. They just white knuckled it through life. Still resentful, still hateful, still angry, but just not using. Those are different things. So continued use is one category. There are treatment responses for that. There may be some sanctions also appropriate if, you know, depending on what is leading to the continued use. But the other category, again, is episodic use. This might be called a lapse. This person's in recovery. They are committed, but they return to use. Maybe they ran into a situation they couldn't handle, a higher situation. Either they didn't choose to try to manage, or they didn't have or know this, you know, how to do so. In this case, their motivation for change is certainly lowered because they use, but it's quickly restored. They quickly get back on the right track, back committed to doing well. And for this person, we never had to rely on the drug test to know they used. How do we know they used? They tell us, and then hope that drug test will confirm it. But when it's that, you know, when it's a lapse, a true lapse, one indication is the person comes forward right away and lets us know what happened. The other category, again, is a full recurrence. Yes, for a person in recovery, recurrence doesn't happen if you're not in remission. And remission doesn't apply if you're not already addicted. So it happens for a person in recovery, in remission. It is not just a single episode of use. It is now a pattern of return to use, and symptoms return as well. They are now back living with active substance use disorder. And this occurs despite this sort of overarching commitment to recovery. They were on the right track and still want to do the right thing. They're back in trouble. We can help them fix that if we don't lose them. We can help them fix that if they don't give up. And sometimes their giving up has nothing to do with us. We can't control that. But sometimes their giving up is because of how we're responding or how our program is set up, that it actually encourages people to give up once they mess up. That's the opposite of what effective treatment courts do. Now, let me give you what I call a recipe for recurrence. If these three things occur around the same time to an individual in recovery, this individual is at very high risk of a substance use disorder recurrence, of a relapse. One is if they're experiencing, whether they're talking about it or not, what I have termed recovery fatigue or recovery boredom. This is where they are doing well. This is a special risk in that first year or so. This isn't a person who's been in recovery for 5 years. This is the person in that first year or so. But they just kind of tired of it. They're tired of the rigor. They're tired of all the things they have to do. Perhaps part of what they got out of addiction was it was quite exciting and stimulating when they were under the influence, or when they were trying to get it or whatever, and they kind of missed that. And sometimes that, you know, and maybe they're kind of bored with it now. And maybe that's because they need a fuller recovery. They need exposure to more experiences. They need more healthy connections. They need more things to do in recovery. It's gotten too narrow. Maybe it means they need to relax more. They need to introduce more fun into their life of recovery. Because now that they're back under control, they're now working, they're doing the drug court stuff, they're trying to go back to school, it's too much. Other times it's something that's a little more, has a little more pathology to it. Maybe, you know, in addiction, their life was chaotic and out of control. And they got used to that. Their brain got used to that. You know, when your brain is overstimulated with chaos, it releases chemicals to try and calm you down. In a life full of chaos, the brain is constantly trying to release things to calm you down. And then in recovery, things calm down, things get normal, and it doesn't feel right. It makes the person uneasy. It doesn't feel normal. They feel like they need more stimulation. This is all beneath their consciousness, but it's a thing. I work with people who have identified that they always end up messing up if things are going too well. Sometimes that's not just bad luck. Sometimes that there is psychologically they're sabotaging themselves because normal doesn't feel normal yet. And so, folks, I'd be normalizing that for folks. I'd be letting them know that can happen. Don't be ashamed of it. Don't be ashamed of it. Put some light on it. Talk about it. Well, if a person is experiencing recovery boredom or recovery fatigue, and they've also been experiencing euphoric recall, and that is, whether they're talking about it or not, they're beginning to remember the old days, not like how miserable I was, not the emptiness and heaviness that I felt, not all the crap I got into, but they're beginning to remember like the part that was good, the part that felt good, the part that was fun, was exciting, that was straight. They like that. They start thinking about that. And in the process of that, and maybe they're talking about it too, the process of that, they're starting to get little bumps of dopamine, nostalgic dopamine. That's called euphoric recall. That's not doing my first step, or my fourth step. It's not, talking about my drug history so I can, as a part of breaking my denial, or it's not doing a lead in the meeting. It is reliving out loud or in my head the good parts of the past, getting a little high from that. That's super dangerous, but it's also super common. So part of good recovery management, part of good recurrence prevention is letting people know, that can happen. And here's what you do about it. You talk about it. You say, hey, this is what I'm going through. This is what I've been thinking. And then help them counteract that euphoric recall with reality. Sometimes what can happen, people, especially my friends, especially in like that first year or so recovery, is like the further you get away from the bad times, you kind of forget how bad they were. And the person can get caught up. So if they're already experiencing recovery fatigue or recovery boredom, and they've been periodically having some euphoric recall, that's a very dangerous situation. And then if something then triggers the abstinence violation effect, if you don't know what that is, please Google it. It's a really important psychological phenomenon that can sabotage success. It's kind of the all or nothing thinking. I was recently a part of a peer support setting where someone said, when it comes to, my addiction, I'm either all in or all out. That was probably true, but it's a really troubling reality, because that means if the person actually has a slip, they pick up again, their brain kind of subconsciously, or as Freud would say, unconsciously says, messed up. Go ahead and go all the way. All in or all out. And no, don't lose me now. It's not even about, maybe they didn't use it all, but maybe they've been having euphoric recall secretly. And just that euphoric recall, like at some point, they begin to, the abstinence violation effect kicks in. They believe, I'm gonna mess up. It's too late. I may as well go ahead and finish this off. Some of y'all are like me, maybe tried to diet sometime. In my whole, since I was in my 40s, I'm always either having just lost 10 pounds, just gained 10 pounds. In fact, my daughter, I have an 8-year-old, and she, they say when you're 8 or you're 80, you don't have any filter. You say what is. She said, Daddy, you have a big belly. I'm like, wait a minute now, little girl, my belly's not big as it used to be, but it is bigger than it was a little while ago. So you're right. But some of y'all like that, and you've been on some kind of plan, and you're rigorous about it. You do the right thing, and you make sure you're eating just right or whatever, and you're on your plan. And then the holidays come, and you decide, okay, I'm gonna go ahead and have a little slither, a cake, a little piece of pie, whatever. I'm gonna put a little extra macaroni and cheese on it, whatever you eat that's good to you. And listen, unless you're a diabetic or whatever, I don't care what plan you're on, a little slither of something's not gonna hurt you. It's not gonna blow your plan. But the minute it happens, you just kill it all. That is called the abstinence violation effect. In an addiction, that can be really a troubling flaw. So if these three things happen at the same time, recovery, boredom, euphoric recall, and anything, whether it's use or not, that triggers this abstinence violation effect, then an SUD recurrence, and sometimes a prolonged one, is inevitable. A part of good recurrence prevention planning is being sure we understand these three, participants understand it can happen, and that we are helping them to, in the clinical setting, in the treatment groups, in the treatment individual sessions, to talk about what's going on and to counteract them. So I'm not going to go into detail on these slides. You have them on your own, but we have identified, or researchers understand, that there are intrapersonal and interpersonal things that kind of impact or can lead to relapse or recurrence. You see the examples of these intrapersonal things inside of them, their emotional state, their ability to cope with whatever they're going through, what they expect to happen if they use again. If your recall convinces their brain, ooh, it's gonna be amazing. You've been clean, yeah, we don't say clean and dirty. You've been not using for all this time. I bet if you pick that up one more time, just one more time, it'll be like it was that first time. The brain can say that. They expect a lot from it, or at the same time, their efficacy, their belief that they can remain well wavers in a moment. Their motivation, their internal motivation, how important does this continue to be for them? How willing do they continue to be? The existence of cravings and urges. All of these things are factors, internal factors, that can put people on the road of recurrence. And we teach people this. We help them understand this. They can monitor themselves, be self-aware of where they are and how they're doing. These are triggers potentially. Then there are interpersonal factors about the level of conflict in their life. How much unresolved stress is there? How much pressure are they receiving from important social groups? How much social support do they have? What's their living environment like? Family history. That history doesn't matter as much as the people right now who are in their life, and those and what they might know and believe about whether recovery is possible in their family. All of these are factors we consider when helping people to develop recovery management plans, recurrence prevention plans that work. And this is the job primarily of your treatment professional. But you all may have a role in reinforcing it, and you should have a sense in general of what's sort of in that plan. If I were a supervision officer, I'd want to know what's in that plan so I can help to reinforce it and help to be among the people who also knows what their relapse path would look like. So I can help them to see if they might be on that path, even if they haven't picked up yet. Let's talk about recurrence prevention and response in treatment court. So what is recurrence prevention? Is therapy. It's therapy that does lots of things. It identifies the person's risk factors, some stuff I've already talked about. It is helping to train. I use that word on purpose. Helping to train people in recovery to routinely engage in recovery supportive activities, a wide range of them. We help expose them to them. We help expose these activities to them or expose them to the activities. We help them to practice how they engage with these activities. We make as homework or the student treatment, hey, I want you to check this out. We're helping them to identify what are the things that both will help you avoid substance use, but also will help you to enjoy life. What are some ways you can cope with all this stress you're under that are healthy? And we, while in treatment, help them to begin to do those things routinely, systematically, hopefully where it becomes like muscle memory. And part of the aim of this, is to help them be able to prevent or respond to early warning signs before they're actually in trouble. And in the treatment setting, it's often centered around cognitive behavioral approaches based in classical conditioning, helping people to understand what are the thoughts and feelings in other situations that trigger urges and cravings that result in use, and helping to replace those, get in the way of those interrupt those before they result in problems. These are some of the components of any good recurrence prevention therapy. It always involves an ongoing assessment of how the person is doing, and if they have had a return to use, assessing what happened there. As I mentioned before, much of it is often centered in cognitive behavioral therapies. Often medications are involved. That's for opioid use disorder, that's the most reliable recurrence and overdose prevention we have is medications, or medications for COD as well. It's the use of contingency management, in particular incentives, by the way. We don't talk about it much, but while incentives and sanctions matter, the truth is research shows incentives matter a lot more. In fact, the research that's been done on contingency management with people living with addiction was only incentives, basically vouchers, because they weren't tied to the justice system, so sanctions weren't an option. So all the success we saw from contingency management, from coordinated responses to behaviors, it was incentives only. And that funding that's out there, that $5,000 y'all can go for, that could also be used to purchase incentives, and some funding cannot. So incentives matter, and especially when reinforcing the behaviors that are going to be required in order for a person to stay well, get well and stay well, using incentives to encourage that, to reward that is really important. If you have people who are repeatedly getting back into trouble, doing well for a while, and then suddenly something happens, if that's a pattern, then the kind of things that you might want to consider, and this is really, the clinicians would know that, but it might be a reminder for you clinicians as well, you treatment professionals, that there's a high correlation between high stress environments and return to use, the need to escape or get relief from those. So stress management, it's almost become a cliche, but it can be really important for individuals who are really struggling. It may be the only way they've ever really learned to cope with high stress situations is to escape them or get relief from them through using substances. So that may need to be focused there. Perhaps they're living with trauma, the impact of trauma, or depression, or some other co-occurring disorder that needs to be addressed and assessed. Sometimes we miss that, especially if it's not primary and if it wasn't a part of what they presented with when they first came in. But as you all know, drug court works, treatment works, and people stop using, and those things they were medicating may begin to surface. I've already talked about the absence violation effect. That is almost certainly a component of what happens to people who keep having periods of success and then messing up. They are almost certainly among the many people who are very vulnerable to giving up if they mess up a little, at least giving up for a while. It has to be, we should do everything we can to prevent the absence violation effect from occurring. We can't control it at all. The things we can do to be sure our program isn't encouraging an all or nothing thinking. And then ultimately being sure people have the right recovery management support. Sometimes that's what it is. It's their living environment. It's too much toxicity in their living environment, or those who are closest to them, or it's the lack of meaningful connections with positive people. To the extent that addiction is about disconnection, recovery is about healthy connections in reality. And that often, yes, it begins with us, but it can't be just us. That's an important part of it. I'm not going to focus on this much, but this is some advice on recurrence prevention plans, what they should look like, what should be in them. I urge the treatment professionals with us right now to look at that and be sure that the relapse prevention plans you have in place have these things, include these elements at a minimum, including that last one, which means as a part of the relapse prevention plan, the person should know, okay, if I actually pick up again, if I have a slip or a lapse, this is what I do. this is what I'm going to do. And that includes notifying somebody right away, 24/7, either recovery coach or a family member, someone right away, calling, leaving a message, either for the treatment provider or the probation officer or the case manager, whoever is monitoring them. And then as soon as we open up, let us know what happened and be prepared to come in so we can get you back on track. One way of counteracting the abstinence violation effect is letting people know just because you make a mistake, you don't have an excuse to be out of control. You still need to do the next right thing. And the prevention plan should outline what the next right thing is. If that's not clear, please chat a question in to Shane about that so I can respond in writing. So here's how treatment courts help prevent recurrence, that we incentivize as a part of our program, people admitting when they have used. That might mean that, well, it means a lot of things, but it means that it ought to be a bigger deal for you to not admit you have used than it is for you to admit it. And we have to find ways to either lessen the sanction or eliminate the sanction when it's appropriate for those who tell us they used. We also ought to be drug testing. Don't believe any hype you're hearing out there about you shouldn't be drug testing in drug court. That clinically, we need to drug test in drug courts. It's helpful. It can both help a person who is struggling to make the right decision, to make a phone call or send a text instead of using. But it also is good feedback for the providers and others of us to see how are they doing. Regular, random, frequent drug testing is a part of effective drug treatment. And if you're treating high risk, high need individuals, you cannot do so well without regular, random, and frequent drug testing. Don't believe anything you hear, no matter who you hear it from, that says anything other than that. We prevent recurrence by focusing on good assessment up front, making sure people are stabilized, have their basic needs met, aren't in distress, aren't in physical pain to the extent we can help that, aren't going through, we're helping them to manage withdrawal, that they're not homeless and in dangerous situations, they have enough food to eat. That's a part of good treatment. And then giving them good treatment, good evidence-based cognitive behavioral therapies, that we are focusing our efforts on recovery initiation, recovery maintenance, recovery management, recovery maintenance for everyone. A judge should be asking, if we're in that second to last phase, or at least by then, ask them what their recovery plans are following completion. The judge should be asking about that. Definitely in the last phase, but I'd start talking about it earlier because it should be being talked about in treatment earlier. Require peer support group involvement. Be sure you have a secular option for those who object to the deity-based nature of AA and NA, but most people don't object to that. If they don't object, you can require it. If they do object, give them a secular option like Smart Recovery Online or whatever. But you should require that, but really incentivize it. That's something I would do some small rewards for as they get engaged in that. And then we talked about recovery checkups. That means some kind of, quick contact initiated by us with the program following completion. And the adult drug court best practice standards say that should happen at least for 90 days following discharge. I mean, up to a year is much better. So, and then use medications for opioid use disorders and sometimes for alcohol use disorders. It should always be on the table for folks who want it and need it. How do you respond to relapse in drug courts if it occurs, or return to use if it occurs? Be prepared to have lots of responses, because that's going to happen. It's a part of the issue. So we don't have a 3 strikes and you're out policy. Be prepared to have lots of responses to be sure we don't hit the top too quick. If we hit the top too quick, then we have nothing else we can do. Reward self-report. Figure out how in your program you make it better to tell the truth than to get caught. You figure that out. Progressively sanction proximal or willful infractions, that may have contributed to the use. In deciding whether to sanction new use, I look largely at what contributed to that, and were they doing things or not doing things in violation, out of compliance with what they've been instructed, they really need to be responded with a sanction. That's the biggest indicator. There may be other reasons, other factors as well. Avoid severe sanctions for behaviors they can't control yet. You don't ignore it. You respond to it with a low to moderate level sanction or with a treatment intervention, but be careful not to set up learned helplessness by punishing people for things they can't avoid yet. Sanctions only work if the person can reliably avoid that sanction, avoid that punishment. Rely heavily and sometimes exclusively on therapeutic adjustments for people who are in recovery and have a recurrence. Sometimes, just let treatment handle it. That's part of how you counteract the absence violation effect. You counteract the tendency to think, okay, I messed up and now it's over. And then use medications. Sometimes they weren't using medications beforehand, but now they're really having trouble getting it together. And so a decision may be made. They may be interested in medications. They may be recommended. It's not a best practice to wait for them to fail before medications are considered. But even if they didn't want it at first, it wasn't recommended at first. If a person is having trouble maintaining their recovery journey, then medication should be considered, absolutely. So finally, folks, after recurrences occur, and even at the beginning, it's really important that we do everything we can to reinstill hope. Remember, hopelessness is fully, must be resolved for people to recover. Our main focus is to keep them on the journey. Drug court responses are never about punishment. It's always about prevention. There's a role for punishment in the justice system. There's a role for retribution. That's not what drug courts are. So our focus, how we're responding, is always about how do we keep them on the journey and help them find more success. And we want to support their self-efficacy, that no matter what happens, they need to know we believe they can still do it, and try and help them achieve the skills that are necessary, help them make the decisions they need to make so they can do it. That's how it works. Folks, I wish I had all day to talk to you, but I don't. If you have some additional questions, please chat those in to Shane. I promise you I'll respond to them this week and get those all sent back to you. It's been great spending time with you. You've been such an attentive audience. I haven't, I don't know how attentive you are, but I believe you have been. Thank you so much, folks. Please invite me, Jeff, to come back when we can be in person. I promise you I'll make it if I can. Thanks, everybody.
Thanks, Terrence. We'll definitely invite you back.
Great. Well, thank you so much, Terrence. Thank you, Jeff. This concludes our day one of our training. So be sure to join us again tomorrow morning, starting at 8 a.m. Mountain Time, for tomorrow's great sessions on responding behaviors with Judge Diane Bull, Shannon Carey, and Helen Harbert. It should be a really good day. So have a good day. If you have any additional questions, do write them in chat, and I will get them to Terrence to answer. Thank you.